I saw that once in that's one the South African accent. That's cool, isn't it? Yes, that's the one that I mentioned. Yeah, but that's DJ Precious. I know Robert Mcebo. She was also used, isn't it? No, but I mean her career.
record, man. Yeah, thanks. I indicated yesterday. Oh, want to say something?
No, I thought the court was addressing us.
Sitting down. Fine.
Thank you. Thank you.
This is the ruling I said I was going to make. So I was just trying to chat a background. And this, a lot of talking by this judge is just intended to demystify the law for the students who are here as to what is happening. Right. I indicated yesterday that due to the pressure in this court, it would not be possible for me to write a judgment within a day after the submissions made by counsel for the state and counsel for the appellant, the respondent, that is. They took the whole day, and then I was bombarded with authorities. Even to this morning, Mr. Robin has provided me with a case of about, it's about what, 3,000 pages?
I believe 4,000.
4,000 pages. So it would not have been possible to peruse all the documents and write a judgment. But what I have done is I have perused the heads of argument, the appellant's heads, the appellant's heads were actually filed at 12 midnight, so I only saw them yesterday in court. I listened to the arguments, I've read the judgment of the court of co, and I'm of the view that I'm able to arrive at a decision. But this decision will just be a ruling. A judgment will follow, which will fully enunciate and elucidate the reasons why I have arrived at the said decision. The appellant had brought an application to be admitted to bail in the court of co. This application was unsuccessful. The court of co refused to admit the appellant to bail and enunciated reasons why the court of co was of a view that it was not in the interest of justice to admit the appellant to bail. Now, the appellant was charged or is charged with the following offenses: public violence. And this I'm elucidating for the reasons which will be apparent in that on or about the 4th of October 2016 at or near the University of the Witwatersrand in the regional division of Gauteng, the accused and diverse other persons numbering in excess of 20 did unlawfully assemble with common intent to forcibly disturb the public peace or security, or to invade the rights of other persons, and the said accused, acting in concert, did unlawfully and intentionally disrupt the academic activities of the University of the Witwatersrand. This is the main charge. Then the subsidiary charge is possession of dangerous weapons, and the third charge is assault with intent to do grievous bodily harm, and the fourth charge is theft, and the fifth charge is malicious damage to property. Because the magistrate's raison d'etre is predicated on the reasoning that it would not be in the interests of justice to release the accused to bail, and that the accused poses a danger to public order and security. I have come to the conclusion that the premise upon which this declination to admit the appellant to bail is not sound in law and fact. Consequently, because this is an appeal in terms of Section 65, Section 65(4) decrees that the court or judge hearing the appeal shall not set aside the decision against which the appeal is brought unless such court or judge is satisfied the decision was wrong, in which event the court or judge shall give the decision which in its or his opinion the lower court should have given. I've already stated that, in fact, in law, I'm of the view that my learned colleague in the court, ACO, the premise upon which he proceeded to refuse to admit the appellant to bail is not, as I've said, sound, and actually, on the premise, it is consequently clearly wrong. This entitles this court then to be at liberty and at large to admit the appellant to bail on the following conditions. Just before I get there, I'm acutely aware that the appellant is a student, and I'm acutely aware that, although I'm an appeal court, I'm also acutely aware that there are problems relating to student activities countrywide. But this court is obliged by the rule of law to take cognizance of the fact that the accused has been charged with public violence. I'm aware that Mr. Mcebo and his team argued that these charges are politically motivated and argued that they intend instituting proceedings for the quashing of these charges. The fact is, at the moment, these charges are extant, and it is not the duty of this court to inquire into the validity or otherwise as to the arraignment of the charges against the accused. The charge of public violence pertinently states that the accused is to be arraigned for disrupting the academic activities of the University of the Witwatersrand. It is trite that the accused has a constitutional right to free assembly and free association and to participate in free educational activities at the university. But, as we all know, these rights are not absolute. Consequently, the court intends to circumscribe, to an extent, the right of the appellant, more especially that he's being charged with public violence. So, with that background, then, the following order is made. The appellant is submitted to bail, which is fixed in the amount of 2,000 rands. Right, and the attendant conditions are that, one, the appellant is ordered to desist from unlawfully disrupting the academic activities of the University of the Witwatersrand. Just as a caveat, he is entitled to participate in any lawful activity on campus. The only circumscription of that right is because you are facing charges of public violence. You are to desist from participating in unlawful activities which are intended to disrupt the activities, the academic activities of the University of the Witwatersrand. So that is the first reason, or condition rather. Secondly, the appellant is ordered not to interfere with the investigation of the cases or charges preferred against him. I've already annotated them. 3, I'm not aware if the state has provided or furnished the defense with the contents of the docket, which would contain the list of witnesses. But I'm making this a third condition. The appellant is prohibited during the course of this trial, if it eventuates, to communicate with the witnesses, which will be called by the state intended to give support to the charges preferred against the appellant. Okay. That concludes the conditions. Fourthly, this court, as I've indicated, will furnish the reasons which predicate the setting aside of the decision of the court ACO in a judgment to be handed down within 14 days. Okay, so both parties will be advised as to when if I finish the judgment earlier, it will be before 14 days, but at the most 14 days, okay?
As the court pleases, Ma'am.
All right, thanks.
Where's the court, please?
Okay, the court will adjourn then.
When is that Tuesday? Zasha.
Okay.